Welcome to our seminar series and thank you for joining me. My name is Claire Athis and I'm a family law barrister at Dean's Court Chambers, specialising in finance and private children's work. Today I'm going to consider an example of a client who settled their financial case in February 2020 before the announcement of the world pandemic, and now, as a result of the impact of coronavirus, say that they want their final order set aside. My client is Mr. Smith, who signed a consent order in February by which he kept sole ownership of his restaurant business, established and built up by him within this 15-year marriage. He has drawn a good salary and significant dividends in each of the previous 7 years, and it's envisaged that he will rehouse himself with these means. Mrs. Smith is a supermarket manager, and the former matrimonial home was transferred into her sole name. Looked at now from a post-coronavirus perspective, husband is dissatisfied. He has had to temporarily close his business, but more importantly, he cannot see a way of returning to previous profitability, given his reliance on closely packed tables full of city centre office workers. Wife, on the other hand, is relatively unaffected so far. Had he known then what he knows now, he says he would not have agreed to these terms. So, can he have the order set aside? Of course, there is no right to vary this capital division, but could Mr. Smith argue that the impact of COVID-19 constitutes a Barder event? In 1988, Mr. Barder successfully appealed out of time against the order which had transferred his former family home to his wife. The Barders had 2 children, and 5 weeks after their final order was made, tragically, both wife and children had died. The only beneficiary of wife's estate was her mother, who had no need of the house. The appeal was allowed on the ground that there had been a fundamental assumption that the wife and children were going to need the home for some years, and that had been vitiated by subsequent events. There were further appeals to the highest level, but the House of Lords confirmed that Mr. Barder's order would be set aside. However, the floodgates would remain closed. Giving leave to appeal out of time should only occur where the appeal, if heard, was almost certain to succeed because of a supervening event which happened shortly after the making of the order, upon an application made promptly, which would not prejudice innocent third parties. Since the decision in Barder, the majority of applications based on supervening events have failed, and it is generally considered to be a high-risk application to make. On the slide, there are 2 examples for you of successful applications, both setting aside needs-based awards, where, shortly after the final order had been made, the needs in question had, unexpectedly, disappeared. The important legal principle of finality of litigation generally overrides any supervening event. In Mrs. Cornick's proceedings, the district judge had made a lump sum order giving her 51% of the capital assets. Shortly afterwards, Mr. Cornick's company shares increased in value enormously, so that wife's lump sum represented only a 20% share. Wife sought leave to appeal out of time on the grounds that the increase in the value of the shares was a supervening event which justified reopening the case. However, it was found that wife could not appeal. To qualify, the supervening event had to be both unforeseen and unforeseeable. Parties should not seek to profit by later changes in fortune once they were divorced and their capital divided. The other side of the coin was considered in the Meyerson case, in the context of the 2008 global financial crisis. At the time of Mr. and Mrs. Meyerson's FDR, their assets were valued at £26 million. It was agreed that wife would receive 43%, largely in cash, and husband would retain 57%, largely in shares of one company worth £2.99 each. A year later, post-crash, husband's company shares were worth only 27.5p, altering the division to 14% to him and 86% to wife. Husband said the drop in share price constituted a new event which undermined the basis or fundamental assumption on which the order was made, in other words, a Barder event. Husband's appeal was dismissed. Although extreme in extent, the court found that the fall in the share price was a natural process of price fluctuation and not an unforeseeable event. Husband had taken a speculative position, and the court should not subsequently relieve him of what had turned out to be a bad bargain. Of note for Mr. Myerson was the fact that the payment of the lump sum to wife was spread over 5 instalments, of which £2.5 million was left to pay. So there existed, and husband had invoked, the statutory power of variation, which could enable husband's needs to be met. So, to return to Mr. Smith and our case study. As the quotation on the slide in front of you from Lady Justice Hale, as she was then, in Cornick, which was repeated in Myerson, suggests, the Barder principle is not ruled out where an unforeseeable event has substantially changed the balance of assets arising from the final order. Surely the unprecedented nature of the impact of coronavirus was unforeseeable. Mr. Smith could seek to revalue his business and argue that the share of assets awarded is now unfair. But perhaps a better route to take would be to argue that his identified housing need can no longer be met from the dividends and salary which had been a reasonable expectation at the time the order was made. It would seem arguable that COVID-19 has restructured the economy in such a way as to create unforeseeable unfairness in certain circumstances, where, as for Mr. Smith, what would have been considered a relatively safe asset is now unproductive, for example. Ironically, much will depend on the long-term prognosis of Mr. Smith's business prospects, but of course any such appeal will be time-limited. Given that, it may be worth having a trawl through your recent cases now, so that advice can be given to clients promptly. Thank you for listening to this seminar, and if you need any specific advice on this or any other issue, then please contact our clerks at Dean's Court Chambers.